Daubert, the Supreme Court established the rule which is found in the Federal Rules of Evidence 702 as to what's necessary to have a reliability standard so that the expert witness can come forward and give testimony. In a courtroom proceeding, a so-called Daubert motion is a motion where you argue that the standard or principles or approach of the expert are not reliable, they're not documented, they're not established, and therefore the expert witness's opinion should not be permitted to be heard. That's a Daubert motion, and sometimes in a courtroom case, you'll have a preliminary hearing as a part of the motion where the expert may be questioned about the reliability of the scientific method or standard that's been used. Now, can you make a Daubert motion in an arbitration? The answer is yes, assuming that the arbitration panel is prepared to take motions at all. I think it's fair to assume that the leaning of most arbitrators would be to decline to preclude the use of an expert. In other words, as is often the case in arbitration, the arbitrator is more likely to say, I will take the testimony for what it is worth. And therefore, a Daubert motion in an arbitration may very well not succeed. Having said that, there may be a tactical advantage to make the motion. If it's a strong motion, it may cause the arbitrator from the beginning to question the reliability of that expert witness. And while arbitrators hopefully are able to bring an even keel and a neutrality to the hearing later on, we're all subject to being influenced by a motion like this, and it may cause us to question later on and to think more about how reliable we believe the expert's opinion may be. So bottom line, although I have not seen much use of this, I think a Daubert motion is perfectly acceptable in an arbitration proceeding, and you may get the right panel that decides, you know what, this is an extreme case and I'm going to grant the motion, but even if not, there can be value to having made the motion.